Welcome to the Deep Dive, where we take complex information, distill it, and help you get well-informed fast. Today we're embarking on a really fascinating deep dive into a brand new piece of legislation out of South Africa. It's the Cannabis for Private Purposes Act 7 of 2024. And this isn't just another law, it's a significant development that aims to fundamentally reshape how cannabis is legally understood and treated in the country. Our mission today is to unpack this consolidated act in a clear and hopefully engaging way. We want to give you its true purpose, its most crucial provisions, the broader legal context it operates within, and importantly, what it really means for everyday people. And, even for those of you studying the law, we've got the full act right here, signed by the President May 28th, 2024, published June 3rd. Now, it's still technically to be proclaimed for its official start date, but the groundwork is definitely laid. So what exactly is this act setting out to achieve at its core?
Well, what's really foundational here, and quite interesting, is that the Act begins by explicitly stating its objectives. That gives us a powerful glimpse into its intent. It seeks to uphold the right to privacy of an adult person to, use or possess cannabis. But crucially, it simultaneously regulates that use. It's trying to strike a balance.
Right. That's a fascinating tightrope walk. Acknowledging a personal right, but immediately carving out boundaries around it. Is that sort of the central tension here?
It absolutely is. And it also directly addresses the issue of children and cannabis. It makes sure that any prohibited use or possession by minors is dealt with solely in their best interests, and prioritizing welfare over punishment. And a critical point right from the start, it strictly prohibits dealing in cannabis. This isn't about opening up a commercial market.
Okay, dealing is off the table. And something that immediately jumps out, especially thinking about South Africa's history, is the expungement of criminal records. That sounds like a really profound step, not just a legal footnote.
Oh, it's much more than a footnote. It's a genuine attempt at, social justice, maybe, designed to provide relief for past convictions. Convictions often based on presumptions under older, much stricter laws. The Act also makes it clear it will amend provisions of certain existing laws. That really shows how comprehensive it is, how it weaves into the existing legal fabric.
Okay, so to really get a handle on this act, we first need to get on the same page about some key terms. Because, like always in law, definitions are absolutely everything, aren't they? We need clarity on who's an adult person, what exactly cannabis means in this context, and what's a private place versus a public place.
Spot on. An adult person that's defined simply as someone 18 years or older. Pretty straightforward, but, crucial because everything else hinges on that age. And when we talk about cannabis itself, the Act is quite specific. It means the flowering or fruiting tops of the plant and products made from them. But, and this is important, it excludes things like seeds, seedlings, the stalk, leaves, and branches without any fruit or flower, and the roots. So not just any part of the plant counts as cannabis under this Act. That's a significant distinction for anyone growing or using it.
That distinction is absolutely key, yeah. So the Act isn't just saying the plant is legal. It's defining which specific parts fall under these new rules. Makes sense. And what about that critical difference between private and public places? That seems to be right at the heart of the Act's philosophy.
It truly is the bedrock, you could say. A private place is broadly defined as any area the public doesn't have access to as of right. Think your house, a specific room, maybe a shed, or even your own land. It also specifically includes bits of communal land that, by community rule or custom, are exclusively used for private cultivation or use.
Okay.
Conversely, a public place is anywhere the public does have a right of access, or communal land that isn't designated for private use. This really sets the stage for where you can actually use cannabis legally.
Right. So we've laid the groundwork with definitions. Now, for the big question, what does this Act actually allow an adult to do? Section 2, that's where the everyday reality of this law comes in, right? Spelling out the do's and don'ts.
Exactly. The core permission is clear. An adult person may use or possess cannabis.
Okay.
And importantly, they can provide to or get cannabis from another adult person without the exchange of consideration.
Ah, that phrase again.
Yes. It means absolutely no money, no gift, no reward, no favor, no benefit changing hands, nothing. This has to happen per occasion, in a private place, and for a private purpose. It clarifies that social sharing among adults is okay, but crucially, it shuts down any kind of commercial transaction, even small scale.
That without consideration clause is incredibly powerful then. It explicitly draws a line against any form of commercial activity.
Got it. But even within your own private space, your home, there are limits, correct? It's not a complete free-for-all inside your own four walls. That's right, absolutely. An adult may not use cannabis in a private place for a private purpose if a child is present, or if another adult who doesn't consent is present. This raises, important questions about personal space and respecting others' choices and well-being, even in your own home.
And what about the reasonable distance clause? I remember seeing that. That sounds like it could be tricky maybe for people in apartments or close communities.
Yes. That one could be interesting in practice.
Is the act giving any specific guidance on what reasonable actually means, or is this something that's likely going to be figured out through, court cases later on?
Well, it specifies that cannabis can't be used within a reasonable distance from a window, ventilation inlet, doorway, or entrance of another place, or where smoke is likely to cause a disturbance or a nuisance to others nearby. It doesn't give a meter measurement, no.
Right.
But the intent seems clear. Prevent passive smoke and nuisance from bothering neighbors. So while you have your private right, it doesn't mean you can infringe on your neighbor's peace and quiet. This is exactly the kind of clause that will need practical interpretation, probably case by case.
Makes sense. And one final, really vital clarification for understanding the public sphere. Can you possess cannabis in a public place? Carry it with you?
Yes. An adult person may possess cannabis in a public place.
Yeah.
But, and this is a clear line, they're strictly prohibited from using it there.
Okay.
So you can carry it, transport it, but public consumption remains illegal. That gives a clear distinction for law enforcement and, well, everyone.
Good distinction. Now, the Act clearly puts a high priority on protecting children. That seems to be a central theme running through it. It really seems to go to great lengths. What specific measures does it put in place?
The best interest of the child is stated as paramount in all matters regarding cannabis under this Act. So if a child is suspected of, say, possessing or using cannabis, they aren't treated like an adult offender. Instead, they're dealt with under existing child-focused laws. The Children's Act, the Prevention of and Treatment from Substance Abuse Act, or maybe the Child Justice Act, especially if it involves suspected dealing. It shifts the whole approach from purely punitive to one focused on welfare, support, and rehabilitation.
So it's much more protective rather than just prosecutorial. That makes sense for children. What are adults strictly absolutely prohibited from doing when it comes to kids and cannabis? It seems like a very firm line is drawn there.
A very firm line indeed. No adult person may knowingly permit a child to use or possess cannabis, or supply cannabis, or even a product containing cannabis to a child. It's an unequivocal ban, designed purely to protect minors.
Is there any exception at all to that rule about supplying cannabis to a child? It sounds like a total blanket ban otherwise.
Yes, there is one very specific, very important exception. A responsible adult may administer cannabis to a child, even without the child's consent or knowledge, only if it has been prescribed by a medical practitioner.
Ah, medical.
Exactly. This carves out a crucial medical pathway, distinguishing therapeutic use under doctor's orders from any kind of recreational or illicit supply.
Okay. And what about just having cannabis around children? It's not just about actively giving it to them, but about presence and accessibility too, right?
Precisely. Adults who possess cannabis must take reasonable measures to ensure it is inaccessible to a child, whether that child is directly under their care or just visiting, for example.
So safe storage is key.
Safe storage is vital, yes. And furthermore, no person may engage a child, get a child involved in dealing cannabis, which, as we'll see, carries a very, very severe penalty itself.
Okay, so with all these rules and protections laid out, what happens if you break them? Section 4 gets into the offenses and penalties. This is crucial for understanding the real-world teeth of the Act for everyone, public and legal students alike. This is where the legal weight comes down.
It is indeed. Dealing in cannabis is the most serious offense listed. It really reinforces the Act's clear intention. Decriminalize private use, yes, but keep a strict prohibition on any commercial activity. Penalties can go up to a fine, or imprisonment not exceeding 10 years, or potentially both. That's a significant deterrent.
10 years is a serious chunk of time. It really underscores that stance against commercial dealing. What about the other offenses, particularly the ones related to children, or maybe just having too much for private use?
Right. So knowingly letting a child use or possess cannabis or providing it to them outside that medical exception we talked about, that carries a fine or imprisonment up to 12 months, or both. Engaging a child to deal also carries that very stiff penalty, up to 10 years, putting it on par with the general dealing offense. And for those who might say over-cultivate or possess amounts that go beyond what's considered personal for private use, that can lead to a fine or imprisonment up to 5 years, or both. Now, it's important to mention here, the specific maximum amounts for private possession and cultivation haven't been finalized yet. The minister will prescribe those details through regulations later on.
Okay, so watch this space for the exact limits. And for those more, I guess, common everyday violations like using in public or maybe causing a nuisance with smoke drift, what are the consequences there?
For those kinds of offenses, like failing to store cannabis securely away from a child, using it in a car on a public road or a passenger breaking transport conditions, or using cannabis in a public place, or using it in a private place right in front of a child or a non-consenting adult, all those carry a fine, currently set not exceeding R2000. Also, smoking privately near a window or in a public gathering area causing a disturbance, that also falls under the R2000 fine category.
And a key point here for people thinking about their record. Those fines, if they don't come with an alternative of imprisonment, they don't count as a previous conviction. That's a significant detail, right? Differentiating minor infractions from actual criminal record.
Exactly. It's an important distinction in the practical application of the law.
Okay, this next part feels really transformative, especially given South Africa's past drug laws. The Act deals with expunging past criminal records. How does this actually work? This feels like a big deal for a lot of people.
It is a very big deal. This is a critical legal contest representing a significant step towards, well, maybe righting some historical wrongs. The Act allows for the expungement of criminal records for people convicted in the past for cannabis use or possession under older laws. Specifically, the 1971 Abuse of Dependence-Producing Substances Act, the 1992 Drugs and Drug Trafficking Act, or similar old laws from their former TBVC states or self-governing territories before the 1993 Constitution. It's basically about recognizing that what was once a crime, simple use, or possession isn't anymore under this new framework.
So these are indeed historical convictions being addressed. Is it an automatic slate cleaning process, or do people need to actively apply to get their record cleared?
For simple use or possession convictions, the intention is for expungement to be automatic, handled by the Criminal Record Center of the South African Police Service, which is, a huge relief for potentially many people. However, if for some reason it doesn't happen automatically, individuals can then apply in writing to the Director General, Justice and Constitutional Development to get it sorted.
Okay, automatic for use possession, application needed if it slips through the cracks. What about past convictions for dealing in cannabis? Is expungement possible there too, or is that distinction firmly maintained?
For dealing convictions, expungement is possible, but only if the conviction was based on the operation of a legal presumption under those older acts.
A presumption, meaning?
Meaning, if they were presumed to be dealing just because they possessed a certain amount, rather than based on direct evidence of actual selling or commercial activity. If that was the basis, they may qualify for expungement. But this requires a written application to the Director General. It definitely raises important questions about the fairness of those past convictions that relied heavily on presumptions instead of concrete proof of dealing.
Right. The Director General seems to have a key gatekeeping role here. Can they revoke an expungement once it's granted? Is there a check in place?
Yes, there is a check. If it's discovered later that the applicant didn't actually qualify, maybe the conviction wasn't based on a presumption, after all, the Director General can inform the applicant. The applicant then gets 90 working days to provide compelling reasons why the record should remain expunged. If they can't provide compelling reasons, the certificate can be revoked and the convictions put back on the record.
Okay, so it's a mechanism to ensure the integrity of the process, balancing the relief with making sure it's applied correctly.
Exactly. Balancing relief with due diligence.
Now, beyond the direct rules on cannabis itself, this act also makes changes to other pretty significant laws that has huge real-world impact. The schedule mentions the Drugs and Drug Trafficking Act and, maybe most notably for many people, the National Road Traffic Act. What changes are we seeing there? This really broadens the scope.
Yeah, this is where the legal shifts translate directly into practical implications for basically every road user in the country. The Act deletes cannabis, dronabinol, and THC from Schedule 2 of the Drugs and Drug Trafficking Act. Effectively, this removes them as undesirable dependence-producing substances within that specific legal framework, reflecting the decriminalization for private use that's central to this new act.
But the biggest changes, as you said, seem to be around driving. THC is now explicitly written into the National Road Traffic Act in a very detailed way. That's a major shift and definitely impacts public safety concerns.
Precisely. The Act amends definitions and sections related to things like reckless driving and, crucially, driving under the influence. It inserts THC, right alongside intoxicating liquor and a drug having a narcotic effect.
Hmm.
So driving under the influence now specifically, explicitly includes THC. It brings cannabis impairment under the same serious legal umbrella as drunk driving.
So does that mean there are now specific limits for THC in your blood, similar to how we have blood alcohol content limits? This is vital information for any driver out there.
Absolutely, and this is critical for public safety and for enforcement. For professional drivers like truck or bus drivers, the limit is less than 200 nanograms of THC per 100 milliliters of blood. For non-professional drivers, so most of us, it's less than 500 nanograms of THC per 100 milliliters of blood.
Okay, those are specific numbers.
They are. And it's worth noting these aren't zero tolerance limits necessarily. They suggest impairment at levels that, for some people, depending on how often they use in their metabolism, could be present hours, maybe even days after consumption.
Right, that makes it tricky.
It does. It makes responsible driving under this act quite complex because the effects, or at least the detectable THC, can linger. There are also detailed limits specified for combinations like having both alcohol and THC in your system, or even alcohol in your breath combined with THC in your blood. Very specific thresholds that will definitely have significant enforcement implications and require drivers to be incredibly careful and aware of their state long after use.
This clearly sends a really powerful message, though. Private use is one thing, fine. But impaired driving is completely different and serious, regardless of the substance. The Act makes a firm, unambiguous distinction there.
It unequivocally reinforces the public safety aspect. It expands the scope of impaired driving to explicitly include cannabis, ensuring that decriminalizing private use doesn't come at the cost of road safety. It's quite a comprehensive approach, really, managing all the knock-on effects of this legal shift.
So, going from a time where cannabis users were criminalized just for possession, South Africa has taken this massive step with this landmark act. But as we've really unpacked here, this isn't just about legalizing pot. It's a very delicate, complex stance, balancing individual freedom, child protection, trying to fix past injustices through expungement, and ensuring public safety, especially on the roads. This act feels less like an endpoint and more like the start of a whole new chapter in legal and social adaptation.
That's a perfect way to put it. The Cannabis for Private Purposes Act of 2024 is truly a landmark piece of legislation. It tries very hard to balance those individual privacy rights with public safety and protecting children. It definitely moves South Africa into a new era of cannabis regulation. It outlines clear boundaries for private use, sets severe penalties for dealing, and offers a path for past convictions to be wiped clean. And those detailed changes to the National Road Traffic Act are a critical piece of the puzzle. They underscore that while private use is decriminalized, the responsibilities that come with cannabis use, especially regarding public safety like driving, are now rigorously defined. It's a very comprehensive approach trying to manage all the implications.
Yeah, this deep dive really shows just how multifaceted a legal change like this can be. It touches on personal liberties, child welfare, criminal justice reform, public health, road safety. It's all interconnected. And for you, the listener, especially if you're studying law or policy, this act presents a fascinating case study. How does a society adapt its legal framework to shifting social norms and constitutional rights? And look how complex even seemingly simple changes become in practice. So the provocative thought we want to leave you with is this. As these provisions become fully proclaimed, as South Africa steps into this new legal reality, how will that delicate balance between respecting individual privacy and ensuring community safety actually play out? How will it continue to evolve in practice on the ground? And what unexpected challenges or maybe even opportunities might emerge from this major shift? Thank you for joining us on the deep dive. We really hope this has given you a clear, engaging, and comprehensive understanding of this very important piece of South African legislation.